starten wir. Es stehen zwar noch ein paar Leute draußen, aber mit Blick auf die Zeit, damit wir den Abend mit der Diskussion der Alternativen verbringen können, fange ich jetzt an. Ich darf euch alle herzlich willkommen heißen zur Veranstaltung Investitionen ja, Sonderklagerechte für Konzerne nein, Alternativen zum multilateralen Investitionsschiedssystem. Mein Name ist Alexandra Strickner, ich bin Mitbegründerin von Attac Österreich und Attac ist Teil der Plattform Anders Handeln, die diesen Abend heute hier organisiert. Die Anders Handeln-Plattform ist die Nachfolgeplattform der TTIP-Stoppen-Plattform, die einige von zumindest den österreichischen, aber auch den vielleicht ausländischen Kollegen kennen, wo mehr als 60 Organisationen in Österreich, von Gewerkschaften über Umweltorganisationen, kirchlichen Organisationen, Kulturorganisationen sich eingesetzt haben für den Stopp dieser Verhandlungen. Und Sie sehen hier unten die Mitbegründer der Anders Handeln-Plattform, also das sind eben auch wieder dieser breite Zusammenschluss, es sind Gewerkschaften dabei, es sind Umweltorganisationen dabei, kirchliche Organisationen, auch wir Campesiner. Gemeinsam arbeiten wir auch, setzen wir auch in Österreich die internationale, die europäische Kampagne Rechte für Menschen, Regeln für Konzerne um, wo wir seit über fast einem Jahr schon jetzt wieder das Thema der Sonderklagerechte für Konzerne, beziehungsweise eben dieses System IISD, das für Investor-State Dispute Settlement steht, also Investor-Staat-Schiedssystem steht, wo wir uns dafür einsetzen, dass dieses System endlich beendet wird und es stattdessen endlich verbindliche Regeln für Konzerne gibt, um Menschenrechte durchzusetzen. In Österreich, das ist jetzt auch ein bisschen für die Kolleginnen die Gäste aus dem Ausland, die jetzt in Wien sind, vielleicht interessant, gab es eben von 2014 bis 2017 eine sehr intensive Debatte über dieses System im Rahmen der TTIP-Stoppen- und CETA-Stoppen-Kampagne. TTIP ist eben das Handelsabkommen, das versucht wurde zu verhandeln zwischen der EU und den USA, und CETA eben das Abkommen zwischen Kanada und der EU. Und die Kernforderung dieses Bündnisses in Österreich, aber auch der Akteure europaweit, wir sind ja hier ein sehr breites, europaweites Bündnis, war immer sozusagen an diesen materiellen Rechten, also dass es überhaupt diese Möglichkeit gibt, dass Konzerne, dass ausländische Investoren Staaten klagen können. Wir haben gesehen, dass es sozusagen dann den Versuch gab von der EU, hier drauf zu antworten, aber eben nicht in unserem Sinne, sondern der Fokus der Reformen ist eben sehr stark auf das Verfahren, wie diese Schiedsverfahren ablaufen, und darüber werden wir heute auch noch einmal kurz etwas hören von der Person, die unsere Keynote macht, unsere Opening Remarks sozusagen. Und was daran noch problematisch ist. Warum sind wir heute hier zu dieser Diskussion in Wien? Eben die EU verfolgt dieses Vorhaben, vor allem das Verfahren für Schiedssysteme zu reformieren, auch im Rahmen der UNICTRAL. Das ist auf Englisch ausgesprochen für die österreichischen Kolleginnen, die da nicht so nah dran sind, die United Nations Commission on International Trade Law, das ist die UN-Kommission für internationales Handelsrecht. Die hat ihren Sitz in Wien, und abwechselnd finden eben Verhandlungen und Gespräche in Wien und in New York statt. Und diese Woche finden eben gerade diese Verhandlungen in Wien statt, eine weitere Runde. Und daher sind auch viele Kolleginnen von NGOs aus anderen Ländern hier, aber eben auch Verhandler und Verhandlerinnen aus unterschiedlichen Ländern, und es freut mich und uns sehr, dass wir hier auch heute eine Kollegin aus Südafrika mit bei der Diskussion haben. Der Fokus ist eben der Kommission hier und der EU, dieses multilaterale Schiedssystem, eine Verfahrensänderung voranzubringen. Und ja, das wollen wir heute hier an diesem Abend diskutieren. mit spannenden Gästen. Wir wollen nochmal drauf schauen, was wird da eigentlich verhandelt, was ist dieser Vorschlag einerseits, den die EU hier versucht voranzubringen, mit eben einem klaren Mandat der Mitgliedsländer, das eben 2018 erteilt wurde, und was sind aber eben auch die Alternativen dazu, welche Alternativen gibt es da eigentlich schon in Ländern des globalen Südens. Wir sind da ja als Zivilgesellschaft hier in Europa oder in Österreich nicht allein. Es gibt da auch sehr viel Kritik von den Ländern des globalen Südens. Und dann werden wir uns einfach anschauen, in welche Richtung könnte das gehen, was von diesen Alternativen, die hier vorgestellt oder diskutiert werden, sind wirklich Alternativen und was ist vielleicht sozusagen eben. Insofern freue ich mich, gleich sozusagen die Nathalie vorzustellen. Bevor ich das aber mache, habe ich jetzt 2, 3 Sachen vergessen, die ich auch noch sagen muss. Das eine ist, ich glaube mit Dolmetsch, das ist klar Kanal 1 für Deutsch, Channel 2 for English, also zumindest hat niemand gewunken, das passt. Das andere ist, es gibt auch WLAN, falls Sie twittern, das WLAN ist Union-Event und das Passwort ist Event Rufezeichen 2019. Anschließend an die Diskussion gibt es da hinten dann auch Getränke und Essen für einen informellen Austausch, also rennen Sie dann nicht gleich weg, sondern kommen Sie mit uns und kommen wir miteinander noch ins Gespräch. Und das Letzte, was ich noch sagen muss, ist, es wird hier die Podiumsdiskussion und die Keynote gefilmt, aber nicht sozusagen dann die Publikumsfragen. Ich hoffe, das passt für alle. Jetzt wäre die Gelegenheit zu sagen, nein, wenn das nicht der Fall wäre, vor allem auch für das Podium, aber ich gehe mal davon aus, dass das passt. Ja? Danke. Dann so, habe ich das erledigt und ich darf jetzt die Nathalie Bernasconi-Osterwalder vorstellen. Die Nathalie ist Juristin, sie hat einen Fokus auf Völkerrecht, leitet die Abteilung Wirtschaftsrecht und Wirtschaftspolitik des International Institute on Sustainable Development, das in der Schweiz ansässig ist. Sie ist hat eine langjährige Expertise in Handels- und Investitionsrecht, nachhaltiger Entwicklung, Menschenrechte, internationales Umweltrecht und Schiedsgerichtsbarkeit. Und sie arbeitet auch sehr viel mit Ländern des globalen Südens, eigentlich in allen Kontinenten, rund eben um diese Themen bilaterale und regionale Investitionsabkommen, Investor-Staat-Verträge zusammen und berät und unterstützt sie in diesem Bereich. Und ich freue mich sehr, jetzt Nathalie Bernasconi-Osterwalder begrüßen zu dürfen, um ihre Opening Remarks zu unserer heutigen Diskussion zu machen. Herzlichen Dank.
Also guten Abend. Ich werde auf Englisch sprechen. I just wanted to say something in the lead-up before I even start with the few discussion points. And Alexandra asked me to share this. We're sitting, many of us in this room are sitting in the UN building and participating in the discussions at UNICTRAL. And very often people go around and they distribute flyers about events. So, for example, about this event taking place now, flyers were circulated and put on people's desks. And then one day, or I think it was the second day, I saw this flyer, and I was confused at first because it says, settlement of investor-state disputes, is there a need for alternatives to treaty arbitration? So I was confused because it's just happening now. And I asked Alexandra if she knew about this, and in fact, it's quite interesting because it's like a parallel event questioning whether we should even be talking about alternatives, and it's organized by 2 law firms here. I just thought it was a funny, let's say coincidence or not coincidence, but it's a fun fact. So, well, thank you for the organizers for organizing this discussion today. Today, of course, we're going to talk about investor-state dispute settlement and its alternatives. And as we discuss this, I think it will be very important to keep in mind what is really at the center of this. It's not just investor-state dispute settlement, but we're talking about international investment governance. We're talking about the rules governing investment and capital flows across the borders and how these can be enforced. So, in principle, we would like to be broader than talking just about dispute settlement. But we have little time, and after all, it is the crux of the whole discussion around investment law centers on dispute settlement. So we cannot ignore the substantive rules, but at the same time, it's investor-state dispute settlement that has caused the discontent around this body of law. And it's around this topic that UNICTRAL members are getting together and trying to find solutions. So in a way, it does make sense to talk about a more narrow issue today. So we have about 3,000 investment treaties, and I may say investment protection treaties. So across the world, we have bilateral treaties, we have chapters and trade agreements, and they're all about investment protection. It's about protecting the investor when the investor invests across the border. And usually these agreements have a provision allowing this investor to sue the state in front of international tribunals under the international arbitration system. To date, we have about 1,000 cases that have been brought, and this just in the last 10 to 15 years. So the number of cases is increasing very quickly, and the topics can range widely. Originally, the whole system was put in place to protect the investor from expropriation, from nationalization. Especially after the Cold War, there was this feeling that you had to protect against the taking of maybe a factory or a hotel. But today, it's no longer about just investment protection and expropriation. It's about challenging regulation, for example, for the phase-out of nuclear, for the phase-out of coal. It's about permit denials, when a government decides not to go ahead with a project. For example, in the area of mining, when local communities and indigenous communities are opposed or haven't been consulted properly, the permit process may be stopped and the investor can bring claims. And not seldomly, these awards are very high. Increasingly, in fact, some of the awards are hundreds of millions of dollars, if not billions of dollars, which can be an enormous stress for especially developing countries. So the nature of these treaties and how they were interpreted changed a lot over time, and in large part this was due to the arbitration tribunals, to the arbitrators that were deciding the cases. Because if you today took a treaty and you looked at it, it would look very harmless. But the problem is that the system until today consists of ad hoc tribunals, 3 people that come together, that are chosen by the disputing party, so one by the investor, one by the state, and then these 2, depending on the rules, these 2 will choose the president, or a third party will choose the president. And these 3 people, usually or very often commercial arbitrators, commercial lawyers, they will decide what this treaty means. And they will interpret the treaty in ways that were not imagined by the governments when they signed the original treaty. So governments many governments are upset about this development, and there are different reactions to this reality. I would say there are 3 big trends in those countries that react to this development. First, you have those that circumscribe, they limit the role of investor-state dispute settlement. Then you have those that replace investor-state arbitration with another type of investor-state dispute settlement, for example, a court or a system that is no longer arbitration, but is also about investor-state dispute settlement. And then you have those that abandon investor-state dispute settlement, or they never start using it because there are countries that never had an investor-state dispute settlement, and they introduce alternatives to investor-state dispute settlement. So let's look briefly at those ways that countries apply when they circumscribe investor-state dispute settlement. In this case, one of the examples would be to require that before the investor gets to go to international arbitration and dispute settlement, they have to first go to local courts. They have to first exhaust local remedies, and only then they can go to the international level. This is, for example, what has been done by India in their model agreement. But interestingly, it's also most recently the United States that has adopted this approach in their new North American Free Trade Agreement. So they used to have direct access to investor-state dispute settlement, but now, where it is even still possible, the new North American Free Trade Agreement has introduced the exhaustion of local remedies. Second, another approach is to require consent when a dispute arises. So normally, when you have an investment treaty, it's assumed that the government, the state, is giving the investor in advance, the state doesn't know who it is, the offer to arbitrate. And when the investor brings the claim, this agreement, the consent is perfected, and the investor can bring the claim. Now, Indonesia has moved away from that system and has introduced the fact that they say we can go to investor-state arbitration, but we're not telling everyone from the other state in advance that they can bring a claim. Only when the dispute arises, we will accept on a case-by-case basis. Then there are other ways to limit and circumscribe investor-state dispute settlement. This could be carve-outs. So for example, some of the older treaties from Russia and China, they only allow investor-state dispute settlement to determine the damages in case of expropriation. So a more narrow approach. Even the EU has circumscribed investor-state dispute settlement. For example, if an investor has been involved in a corrupt practice, when it exercised the investment, the investor can't bring a claim. That's also a type of carve-out. And then there are screening processes. So I won't go into details, but I'll move on to the next sort of approach, which is the EU approach that's currently taking place, which is to maintain investor-state dispute settlement, but to replace the arbitration approach. So the EU in its treaties has used this investment court system, which is very much, and I think that we have a European delegate who can explain it better, but it's basically moving away from arbitration, but instead determining a roster of adjudicators in advance who will be able to decide the case. This could be potentially positive, and in the sense that they would be more independent than the current arbitrators are under the current system. It also disallows so-called double hatting. So it would mean that the the arbitrator cannot at the same time sit as a counsel in another investment case. So this is usually the case in the current system, arbitration system, that you can simultaneously be arbitrator in one case and counsel in another, and that's not allowed under this system. They also have introduced an appellate mechanism. So they have a first instance you have to go through, and then a second instance where the investor or the state can challenge the first instance award. Now at UNCITRAL, the EU wants to go a step further and proposes to establish a court with judges to adjudicate investor-state dispute settlement cases. So on the good side, it does clean up some of the problems in relation to arbitration with respect to the lack of independence of arbitrators or some of the consistency issues, because you have right now a system where tribunals come to opposing outcomes and decisions, and it could cut costs. But at the same time, you still only have one class of claimants. Only the investor can bring a claim. And the investor can still circumvent local domestic courts and go straight to the international level. And those, I think, that are the main points, that it's basically still investor-state dispute settlement, except that it's not investor-state arbitration. And then there's the third group of, or type of alternative, let's say, in this case a real alternative to investor-state dispute settlement. And we'll be hearing from South Africa, a country which has moved away from investor-state dispute settlement entirely. In fact, it has terminated its investment treaties and now resolves these issues in domestic courts. There's also the approach of Brazil and the Southern African Development Community, so a regional agreement where the solution is not investor-state dispute settlement, but state-to-state. And then you have Brazil, as I said, has only state-to-state dispute settlement, but also has introduced the idea of solving certain issues at the national level through an ombudsperson. So closer to mediation, solving problems that way that may occur in an investment. And then without going into detail, other alternatives are, of course, political risk insurance that the investor could buy, and as well as negotiating specific investor-state contracts that only apply to the project at issue. So where does this leave us? We've seen that countries have adopted different alternatives, but the question is, alternatives to what? It's really about alternatives that make states less vulnerable, less prone to the risks of the current system of investor-state arbitration, but it's not a real alternative. It's more risk control and controlling damage. So if we were really to think about how to achieve investment that serves sustainable development and how we could achieve international investment governance that serves not just one stakeholder, but many, then we would have to rethink the system more profoundly. But for that to happen, we would have to change the substantive rules. They would have to provide a better balance in the rights and obligations of the companies and the states and other actors. And we would need to design a new set of rules also and institutional structures to deal with investment-related dispute settlement. So if we were to develop this kind of court or structure, it would have to be, one, independent. It would have to take into account the important role of domestic courts, for example, through exhaustion of local remedies and advisory opinions. It would have to allow for the settlement of disputes between states. It would have to allow bringing counterclaims and for the participation of affected third parties. So if you have local communities that are affected, they have to be able to intervene. And finally, in my view, any structure that would be set up would have to be structured in a way that would be able to accommodate the implementation of potential future rules that would hold investors and companies accountable. And this could be, for instance, to allow for torts claims arising from a transnational investment that can't be settled in the courts of the host state or the home state. So, unfortunately, at UNCITRAL, of course, we're far away from that, the discussions don't go beyond, really, the discussion on investor-state dispute settlement and the investor-state paradigm. But for now, I'm hopeful that those governments that want to achieve change will be able to at least achieve some change, to at least achieve some damage control in relation to their existing agreements. Because at UNCITRAL today, the idea would be that you would adopt new rules that could change the treaties that already exist. So I mentioned to you there are already 3,000 agreements out there. So the idea originally in UNCITRAL was that you could retroactively change those agreements through a new multilateral agreement. Now, if those countries that really want change, and if they see that they're not achieving any change, any significant change, I think they should walk away, because a moderate bad outcome in this multilateral context would be worse than just dealing with the issue at home alone. Thank you.
Thank you very much, Nathalie. Multitasking. So I will introduce you now the persons that will discuss with us together what Nathalie has been talking about. And may I ask you all to just come up onto the panel, and then I will introduce you. So please just join us. Koordination da so vorgenommen, und klassisch ist basiert der Women's Corner und der Men's Corner, aber okay, wir können das sein. Okay, I'm very delighted and happy to have you all here, and I will first introduce the panel and then we'll go into the discussion. Next to Nathalie sits Kekeletso Mashigo. I'm very happy that she's here. She's head of the Legal International Trade Investment and Tax Unit at the International Trade and Economic Development Unit in the Department of Trade and Industry in South Africa. And she's also an attorney of the High Court in South Africa. Welcome, Mrs. Mashigo. Next to Mrs. Mashigo is André von Walter. He is leading a team of lawyers working on investment law and dispute settlement at the Director General for Trade at the European Commission. And he's particularly working on investment arbitration and has been also part representing the EU in negotiations for bilateral investment treaties with Singapore, Canada, Vietnam, Morocco, Japan, Mexico, and the United States. And he's also now here in Vienna participating in the discussions at UNICTRAL. Welcome, Mr. von Walter. Jetzt switche ich auf Deutsch. Or no, it's easier for you probably, Keke. I think we need your headphones, so yeah, when we speak in German that you can also understand, yeah. So in that sense, next to Mr. von Walter is Jan Krainer. He is seit Ende 2002 Abgeordneter zum Nationalrat für die Sozialdemokratische Partei, beschäftigt sich seit Jahren auch mit der Frage von Investitionsabkommen und Handelsabkommen und war schon öfters auch an Podiumsdiskussionen oder auch in Petitionsausschüssen, wo zu diesen Fragen diskutiert wurde. Und last but not least, Michel Reimon. Er ist eine Periode lang für die Grünen im Europäischen Parlament gesessen und hat dort auch sehr intensiv zu Handels- und Investitionsabkommen gearbeitet, war hier auch ein wichtiger Partner für uns in der TTIP- und CETA-Stoppen-Kampagne und wird ab nächster Woche im Nationalrat sitzen für die Grünen. Es gab sozusagen vor kurzem Wahlen in Österreich für unsere Gäste aus dem Ausland und nächste Woche wird der Nationalrat neu zusammengesetzt und er wird dort sein. Michel Reimon wird uns, falls wir die Diskussion länger als bis 10 nach 8 führen, verlassen, vorher schon oder um 10 nach 8, weil er eine Einladung hat für eine TV-Diskussion zum Thema Syrien. Das leider gerade sozusagen sehr bedauerliche und tragische Dinge, die dort passieren und dort wird er hingehen, um dort teilzunehmen. Danke fürs Kommen. Und er ist auch sozusagen der kurzfristige Ersatz an dieser Stelle vielleicht auch noch gesagt. Ursprünglich war Leonore Gewessler angekündigt und konnte leider nicht und Michel Reimon hat dankenswerterweise kurzfristig übernommen für die Leonore Gewessler. Gut, so let's move first to South Africa. Nathalie has already been referring to South Africa and that you are one of the countries that, based on the experience with this system, has decided to end bilateral investment treaties, to not renew them. And what you also did is, as Nathalie said, you made a law, it's called the Protection of Investment Act, that went into force in 2015. So you do practice already an alternative. So the question for us would be, well, first of all, do you still have investment coming to South Africa? Because there's always this argument, if you don't have that type of agreements, if you don't have ISDS, no investment is coming. But then can you tell us a bit more about the Act and also what is the experience you have with the Act? And then also, how is the discussion going about this alternative proposal that you have submitted to the UNICTRAL discussion that is taking place?
Okay. So, can everyone hear me? Okay. So basically, to try and answer your questions, I think Nathalie is correct in saying we've moved away from ISDS. I think this basically culminated as a result of South Africa undertaking a review of its bilateral investment treaties. This took place over a period of about 3 years, and the reason why we undertook a review of the bilateral investment treaties was basically because as South Africa we wanted to assess the role of investment in South Africa as a country, and we also wanted to assess the implications and the risks of entering into bilateral investment treaties and international investment agreements. And additionally, we wanted to try and understand what the substantive shortcomings were of the current bilateral investment treaties and international investment agreements, as there was obviously currently a lot of talk going on during that timing period. So among the issues that we identified in the review that we undertook was the fact that BITS favor private investors over public interests, and additionally that BITS actually allow the investors to have direct access to international arbitration as opposed to using domestic courts. So basically they bypassed the domestic system. And then the outcome of our review, which took place in about 2010, was the fact that we then adopted a new investment policy framework at the end of 2010. And the new policy that we adopted basically aims to modernize and strengthen South Africa's investment regime and the protection that we offer to investors. And while obviously trying to show investors that we still remain open to investment, but ours was to ensure that there's a balance between investor rights and the protection that investors get, and also the right to regulate for the country, because we didn't want instances whereby we introduce policies or regulations and then we are faced with a claim from an investor. So we basically wanted to preserve the sovereign right to regulate in the public interest, but while also offering adequate and efficient protection to investors. So what happened is, after the review we undertook, in fact, let me take a step back. While we were actually undertaking the review, we actually undertook extensive consultation with business, with labor, private sector, both international investors, national stakeholders, international organizations as well, in terms of what we were doing and what we sought to do and what we sought to achieve. And we also took the review process through cabinet, and basically the decision to terminate bilateral investment treaties was basically a cabinet mandate that we undertook. And cabinet basically instructed the government to basically roll out 5 measures. So one of the measures was to come up with the Protection of Investment Act. The other measure was to terminate bilateral investment treaties and not enter into bilateral investment treaties. The other one